Welcome. We're going to get started with Alex Cherup here from Nevada Legal Services. He's been instrumental in the guardianship supported decision-making world here in Nevada for individuals with disabilities. Alex, feel free to introduce yourself. Thanks for joining us.
Great. Thank you, Maria, for the introduction and for the ability to present today. This is an exciting discussion that's going to merge nicely with the morning content from Sky earlier. And I have to say, Sky, I caught the tail end of your presentation, and it's a pleasure to hear such great work happening, especially in some of the rural and frontier regions in Nevada, and hope to connect in the future. I'm glad that we have imaginative visionaries across the state. When we think about what is possible, the importance of high expectations, the importance of inclusion, and the importance of decision making. All of these topics are going to be discussed in the next hour and 15 minutes. We're going to go through step by step why Nevada is one of the best states in the country, and that our laws, related to our laws for supported decision making and other alternatives to guardianship in the country. What's important about today's discussion is this is the key component that includes every aspect of transition to adulthood. Before we get started, I will note that we may be joined by Catherine Nielsen, who is the Executive Director of the Governor's Council on Developmental Disabilities. If not, we will likely hear from her later during this series. I'm going to just start the slides, which I believe were provided prior. And all of these materials I can supply to Marcia and Maria. In addition to that, I have a multitude of different resources that'll assist in the details related to this topic. Okay. I also would like to thank the Center for Excellence in Disabilities and Diana Ravetti, way back when, who was instrumental in the creation of this structure for supported decision making. Some of you may see some familiar faces throughout the presentation in a couple of videos and pictures. But the Center for Excellence in Disabilities not only was helpful in the development of these resources for supported decision making, but very helpful in my participation in advocacy in Nevada. The Center for Excellence in Disabilities, and Marcia knows this better than anyone because Marcia was, I believe, the first person to sign my checks when I came to Nevada in 2008 as an AmeriCorps Vista in the Youth Transition Project, as an AmeriCorps Vista focusing on transition of youth with disabilities into adulthood. At that time, it included discussions about employment, post-secondary education, independent living, self-advocacy. Now, nearly 20 years later, we're talking about all of those topics in addition to helpful and important ideas related to how all of those topics related to transition into adulthood is incorporated in the decision-making process of an individual with disabilities to ensure that there's high expectations and that the individual's voice is front and center. So the Center for Excellence in Disabilities is where I got my start way before I even thought about what a lawyer can do to advocate for individuals with disabilities. In addition, I'm going to speak briefly about Nevada Legal Services, my organization. We're the state's only statewide legal aid organization. We serve all 17 counties. We have offices in Las Vegas, Carson City, Reno, and Elko. Our focus is on access to justice in civil legal matters. 92% of individuals who have a civil legal need that impacts their lives directly do not have access to an attorney. So it is our office and other legal aid offices across the state that focus on ensuring that individuals have civil legal supports for their civil legal needs. Guardianship, special education, disability rights, matters related to the Olmstead decision as it interprets Title II of the Americans with Disabilities Act are all civil legal matters. And I encourage folks, we'll have information as the slides continue about how to get in contact with our office and other offices that might support you in your efforts to ensure that there is integration of individuals with disabilities and that the law is followed. Additionally, today's content is not legal advice. We're going to go through some legal information. If you do have questions where you think, hey, you or a family member might be eligible for our services, then please don't hesitate to reach out and contact me or others in our office. Some of the key areas where we do offer support, in addition to the topics that I've mentioned, are landlord-tenant, representing and supporting individuals who are tenants who might encounter barriers, eviction notice, habitability matters, those types of areas. Also, public benefits. Our office does support individuals if there are disputes related to the Social Security Administration, unemployment benefits, Medicaid, Medicare, SNAP benefits. 27,000 termination notices went out earlier this month because of the changes in law related to a waiver for a work requirement. All of these areas include disability rights. And when we talk about the importance of youth transition, these are all aspects of being an adult, and disability intersects with these areas of law. So those are some examples of types of supports that we can provide at our office. So let's talk fundamentally about supported decision-making and what that is. I apologize here. I don't know why that. All right, you can see the slide now there. Supported decision-making as a philosophy is a tool that allows people with disabilities to retain their decision-making by choosing supports to help them make decisions. This is the least restrictive method of decision-making. Supported decision-making is a part of a process to achieve independence and self-reliance. It's about making and selecting choices. It's about person-centered planning and developing a plan for the future. And it's about self-determination, taking action in your life to get things you want and need to implement your person-centered plan or your vision for who you are and your future. In Nevada, a new law was signed by the governor in 2019. And we're going to talk a bit about that a little later. But before we get into the mechanics of supported decision-making, I want to just take a step back and focus on the fundamental principle that supported decision-making is a key component related to how an individual will interact with the entirety of the world upon turning 18 years old. We think about decision-making when somebody reaches the age of majority, which is a term that likely has come up in this session before. Ultimately, that's when an individual turns 18. The age of majority and that part of transition means that the individual is no longer lacking capacity because they are under the age of 18. Disability or no disability, if you're 17 years old or you're 18, you do not have full decision-making capabilities because you're a minor under the law. Upon turning 18, these decision-making structures change, and decision-making becomes the responsibility of the person who turns 18. Because of the fact that individuals need extra support and that the laws were focused on structures that were not necessarily inclusive of individuals with disabilities, a structure of guardianship was created. That structure means that decision-making, if a guardianship occurs as appointed by a district court, that guardianship then creates decision making as a responsibility of the surrogate, of the another person that is appointed by a court. The court finds by something under the law, a standard of review. And by the way, this is just not meant to be a in-depth discussion about the complexities of the law, but instead just a review right up front about what happens. That judge determines that somebody who is petitioning for guardianship, that the guardianship, if appointed, means that the individual under guardianship, the protected person, is found to have be incapacitated, meaning they don't have capacity to make decisions. Here, with supported decision making, we're saying that if we have full guardianship on one side, which is the idea that somebody else makes decisions because there's a lack of capacity, and supported decision making where somebody supports decision making and the individual retains capacity, and there's a lot of different options in between. This is the way in which we start with a process that ensures that individuals don't get to that incapacitated finding under guardianship before we look at other alternatives like supported decision making and many other lesser restrictive alternatives to guardianship that key in on those principles that I identified previously. To demonstrate this in a way that is representative of the philosophy of nothing about us without us, which is key to understanding concepts, I'm going to play a short video that goes through what supported decision making is with some of our friends that you may recognize. So let me get this out of the way, and I hope, let's see, are folks real quick, are folks able to hear that, Maria?
Well, I can't hear it.
Let's see, can you hear it now?
No.
So Alex, when you share, you need to click on the button that says share the audio with the video. So you might want to unshare and then reshare the video.
Okay. Content only over the shoulder as background. I didn't know I had share sound. What is this over the shoulder? Oh, I didn't realize that.
Throw salt over your shoulder.
Yeah, isn't that interesting? However, I've been giving Zoom presentations now for like a decade, and I never realized that I could do it as background. Okay, well, you don't need to see this over my shoulder. I'm going to keep it as is, but thank you. A round of applause for Marcia and Maria for helping me out here. And all right, let's see. How does this sound? Well,
Make decisions.
Can folks
Some
hear
need
that?
more support than others.
We can hear it, but we do not see the video playing.
Oh, okay. So now we will share screen, application window. That should be the video. Can you see now?
Yes.
Okay. And now I'm going to hit play.
Everyone has a right to make decisions
Is that good?
about their own life, including you.
Yes.
And everyone needs support to make decisions. Some need more support than others. What support do you need? Some people need help to understand information. Some people need help reading information. Some people need help finding information. Some people need help thinking about new ideas or options. Supported decision making is all about identifying a circle of supporters who will help you. Then you can create a written plan that outlines all the details. A plan that you can share with anyone in your life who needs to know, like your doctor, teachers, or landlords. It's all about surrounding yourself with people who can help you make the best decisions for yourself. Because ultimately, you will make the final choices for your life.
Hey, listen, if you own a business that makes over $200,000 per year in...
I do not want to think about that right now, about a business that makes over 2,000. Okay, let's reshare. Right. Okay, so can folks see the screen again?
Yes.
Right. So that is a description of fundamentally what supported decision making is capable of achieving in your individual experiences. So I talked about the fact that this is a law in Nevada. And when we talk about laws in Nevada, since I have my computer in front of me, I can show you how to pursue a search for finding a law in Nevada. By the way, real quick, around the room, anybody know the answer to this question? What is NRS? Anyone?
That's a great question.
Something Nevada statute, but I don't know what the R stands for.
Yes, excellent. Nevada revised statutes. So in Nevada, we have a great resource in the way in which the laws are presented. And Nevada revised statutes, or NRS, when you hear that in a presentation or in a discussion, that relates to the laws that apply to Nevada. Now, there are other types of laws, federal laws, that will have a different label. But in Nevada, Nevada revised statutes is where you go to find all of the laws. And we have an ability to search online to have access to whatever law we would like to search on Google. Now, importantly, before I share the screen, when we talk about Nevada's supported decision-making law or guardianship law, all of these areas of law are Nevada law. There is no federal law for supported decision-making. There is some federal guidance related to guardianship, but there is no federal law related to the appointment and following process related to a guardian. These are all Nevada laws. So if you're from another state, just moved here, or you plan to move to another state, those laws related to guardianship will be different. What's also key to remember here is when we talk about special education, that overarching law, IDEA, Individuals with Disabilities Education Act, that is a federal law. There are NRS provisions related to special education, but it starts with IDEA as a federal law. That being said, I'm going to share here with you the place where you can find Nevada revised statutes. Basically, what you do is you just go to you go to Google and you type in NRS and whatever the number is. If you type in NRS 162C, then you will find the Supported Decision-Making Act. This will have everything that we will review today related to supported decision-making. All of the content I will discuss is going to be found right here in that Supported Decision-Making Act. So I think it makes sense to write down NRS 162C for your use as you consider these options. And I will also place it in the chat as well, so you have it right at your fingertips. And it does look as Eileen, congratulations for winning to get the first response to that question. And that was a quick response, I must say, but something so important to our understanding of when we think about these particular parts of transition. And like I said, during these sessions, this great webinar series, I'm going to be talking about so much related to transition. At the foundation of each one of those discussions, though, is this concept of decision-making and how it impacts individuals with disabilities. So let's return back to the slides here. Okay. So this, and we call it a new supported decision-making law. It's been law since 2019, so I guess it's not necessarily new, but for many in the community, it is new because it is a change in philosophy and approach. Supported decision-making in Nevada allows individuals to have assistance when making decisions. It is about ensuring that individuals retain rights that are constitutional rights. It's about rights under the Constitution. It's about decision-making and the ability of those decisions to remain with the individual so their rights are retained. Involved in this discussion are concepts that will be discussed throughout this webinar series. Self-advocacy. Fundamentally, self-advocacy is connected with decision-making. And if an individual is a strong self-advocate, then an individual has the tools to be able to start the process for making decisions as an adult. Also, the concept of person-centered planning, which is key, because person-centered planning as a system is a way in which an individual is, as the term identifies, remains at the center of their life planning, and that the person is where it all starts. Back to that idea of nothing about us without us, and the idea that the person with a disability is the expert when it comes to their needs. But what's important to note too when thinking about supported decision-making is for those on the line who have family members, a son or a daughter, or themselves receive services through the regional center and the state of Nevada, person-centered planning is a requirement. And those person-centered planning meetings, which feel a lot like IEP meetings when you're in school, but as an adult, when you've got those person-centered planning meetings, that creates the structure for being able to identify the wants, needs, desires, goals, motivations of an individual with a disability. So this is already happening at that level. Supported decision-making allows that to come into play when we think about how an adult with a disability is able to make decisions. So person-centered planning, both as a philosophy and as a practice under state services. Also, supported decision-making and the law is designed to identify that a person with a disability should be able to live in a manner in which he or she wishes and is capable of making such a decision. I think the first presentation I attended in Nevada was delivered by an incredible advocate named Kathy Snow, who Marcia knows so well and had brought to Nevada. And Kathy speaks about the importance of presuming competence. Supported decision-making presumes competence and identifies that an individual who is in our community should be able to express their wishes and make decisions for themselves. Also, supported decision-making as a law focuses on that adults should be informed and allowed to participate in the management of one's affairs to the best of the adult's ability. In other words, supported decision-making isn't all or nothing, right? Remember we talked at the start of this presentation, guardianship, person is found incapacitated and somebody else is responsible for decision-making. Supported decision-making is on the other side, where an individual retains their decision-making capabilities. But in between that continuum, there is a lot of potential to ensure that an individual receives supports for making decisions. It doesn't mean that a person should be able to identify they can make their decisions or they can't make their decisions, and there's no ways in which there can be additional supports and structures to help. Supported decision making is that support and structure to ensure that there are strategies and management possibilities to ensure that an individual has that ability to make decisions. In the same way, when we have an IEP, we have modifications, accommodations, other types of supports to ensure that the individual is able to receive FAPE and be included in the classroom and to have the least restrictive environment applied. That's the same here when we think about decision making. Now, least restrictive environment, LRE, that you may have encountered in some of the sessions on IDA, is not the term of art necessarily used in law when it comes to guardianship, but you get the philosophy, and that can be applied and should be applied to adults. When it comes to the Americans with Disabilities Act, the term of art or the phrase that we often hear is the most integrated setting appropriate. So most integrated setting is kind of another way of saying LRE. But those principles apply to supported decision making. Okay, so we heard from our friends earlier. We heard from Ian, as a matter of fact, and there's Ian right there, talking about the supported decision making as a concept becomes real because of people. Supported decision making as an idea is possible because of people. Inclusion is possible because of people. People make up community, and a community that excludes one of its members is not really a community at all. So people are key to the implementation of this and other concepts of lesser restrictive alternatives to guardianship to ensure that individuals, to the best of their ability, are able to have the opportunity to be at the helm in their lives and make decisions. So supported decision making, if you read the law, is first and foremost about individuals making an agreement with a common goal for that individual to be who is engaging in the agreement to be able to identify supporters. So let's go through some of the vocabulary. And by the way, I will share with Maria and Marcia the materials that go in depth into this discussion, but also some self-help resources and forms that you can use as templates to assist in this process. The state of Nevada specifically did not create templates, however, because there was a desire to ensure that supported decision-making was not about checking boxes and filling in the blanks. So we talked about the philosophy of supported decision-making. Who are the players? Who are the key cast members to ensure a supported decision-making agreement is possible? First is the person with the disability, the person entering into the agreement. Under law, that person is called the principal. So in this context, the person with the disability looking to create the supported decision-making agreement is called the principal. That principal then chooses others who, unsurprisingly, are identified and easily, they pick the right term, are called supporters. So you've got the principal, and then the principal selects supporters to be the individuals who help and provide the support for the individual to make decisions. This is key because in many regards, when we think about guardianship, the person with the disability does not choose who the guardian is. The guardian first petitions. So this is a switch in how supports are identified. Generally, a person with a disability will choose someone who is known and trusted, someone who has the time to get things done, and someone who will do the tasks required with care and competence. Now, those are the key players. That's basically all there is for an agreement to come together, the principal and the supporters. Now, supporters can then are involved in the process of identifying what unique and customized types of supports can that individual with the disability receive under this agreement. And the agreement outlines those different types of supports to identify how an individual can receive supports to make decisions. This includes the gathering of information, discussion of information and options for the person with a disability, pro and con decision-making skills, assisting in the communication of decisions to others, and advocating for the principal's decisions to be carried out. There are so many ways in which supporters can assist. Those are just a few. And most likely, the types of supports that will assist the individual with a disability in a supported decision-making agreement are a term you may have covered already, but natural supports, already existing supports that exist within a family structure or a community structure. And this is just a way under law to memorialize that structure and ensure that an individual with disabilities has those supports when they are an adult. Some other, I guess, supporting cast members when we think about a supported decision-making agreement are service providers. Service providers, that could be a regional center, a voc rehab counselor, a teacher, a doctor, a dentist, law enforcement official. It's important to note that NRS 162C, which we just saw recently on the screen, the Supported Decision-Making Act, encourages service providers to participate in the supported decision-making agreement and gives them what's called term immunity for carrying out a decision for a person with disability. So this is a protection under law. What do I mean by immunity? Meaning that what the law is referring to is that if a service provider relies on a decision that's being made by a principal who has a supported decision-making agreement, that service provider is not held liable for that decision. A lot of times, service providers are reluctant to accept a decision. The law provides immunity that says, this is the decision of the person. This decision needs to be respected. And as a result, there is no legal liability for the supporter. Immunity is given if a provider, and another term of art here is in good faith, without actual knowledge that any of the signature is genuine or not genuine in the supported decision-making agreement, or if the agreement might be void, invalid, terminated, whatever the case may be. If it is a supported decision-making agreement and that service provider says in good faith that the person has that agreement, they don't need to investigate the agreement. And why is that important? That's important because what we're doing here is we're trying to create a structure under law that allows individuals with disabilities to be able to make their decisions with support, and also that those decisions are not viewed with heightened scrutiny because the person has a disability. The law supports the idea that individuals who rely on decisions that are made by the disability are not held liable, because that is the structure, that is the inclusive world that is possible with supported decision-making agreements in place. One final note before we move on to the next video is the concept of independence versus interdependence. Supported decision-making is all about the idea of interdependence. And interdependence is a structure that exists for individuals with disabilities and their families and individuals without disabilities and their families. July 4th, we're going to celebrate Independence Day. I also encourage you to celebrate Interdependence Day, which is an acknowledgement that we are able to do so much because of the fact that we are part of a larger network called community. Supported decision-making acknowledges and encourages agreements that support this particular fundamental piece when decisions are made. So I want to now move to a video that shows this in real time. This video is going to explain or show and explain how a supported decision-making agreement can be used with a principal and a supporter when pursuing healthcare opportunities and decisions related to the needs of the principal. So,
Alex, really
yes.
quick, there's a question in the chat before you play that video in regards to what you were just talking about with the decisions. So how can these decisions be changed? Needs change with time? How can the agreement ever be altered?
So I think there's two questions there. The agreement can be changed at any time as desired by the principal. So this is not written in stone. We'll go through that a little bit more, but just to answer the question directly, a supported decision-making agreement can be terminated at any time in writing or verbally. When it comes to decisions that are made, that's a more complex question and a good question, which I'll address now. Decisions, whether a person has a disability or doesn't have a disability, are often good decisions, or on the other hand, are often bad decisions. A supported decision-making agreement doesn't put a premium on whether the decision is good or bad. And whether a person has a disability or doesn't have a disability, there might be good or bad decisions. The idea here is that a person with a disability has the opportunity to make decisions, and a person without a disability has that opportunity too. And sometimes those decisions are outstanding, and other times might be pretty bad decisions. I know I've made probably more bad decisions than good decisions if I were to do a review. So when it comes to changing decisions, I think rather than supported decision-making agreements giving the opportunity to change decisions. By the way, if there's a restrictive environment like guardianship and a bad decision is made, that can happen too. But there's something beautiful in the phrase opportunity to fail, because that's part of being a human being. And that opportunity is something that an individual with a disability, without a disability should have, and is part of what it means to make a decision. Supported decision-making agreements facilitate the ability for a person to make a decision, and then facilitate for the ability of a person to respond, react, and adjust if that decision might not have been the best decision. But fundamentally, when it comes to decisions that are made under a supported decision-making agreement, those decisions become the decision of the individual. If there was a bad decision, well, just like in any other circumstance, then that would be a decision that we can use as a learn. We often say the best way to learn is through mistakes that were made as we move forward. That's a fundamental part of inclusion, is the ability to fail. And you'll hear so many disability rights activists, Norman Coons, for instance, talk about, as a person with a disability, how important that is for self-advocacy and for identity and pride in being a person with a disability. Hope that answers your question.
Yeah, Kamala says, I have a supported decision-making agreement with my 24-year-old. She makes some bad, unhealthy decisions, but I made some horrible decisions at that age too.
Couldn't have said it better,
yes.
Right? And in a system where a person with a disability doesn't have that ability to make bad decisions, then that's not necessarily what we're talking about when we're talking about inclusion. We have high expectations for individuals with disabilities, and those high expectations include the entirety of what it means to be a human being. So thank you so much for that question and for the real-time feedback. Yeah, 24 years old. I think I made some really bad decisions at age 23. That was one of them. Yes. The dignity of risk is the term. Marcia's put it in there. That dignity, the dignity of risk is another way to frame this principle. And that's a term of art that we use in the disability rights community. By the way, in this discussion about supported decision-making agreements, we're going to review almost every one of the tenets, the principles of disability rights, because like I said, this intersects with each one of those areas, including the ability to fail and dignity of risk, which is key to a complete and inclusive experience. All right, so let's move on to the next video, which I will put on the screen here. This is a video that is going to show supported decision-making in action in one of those areas where decisions are most fundamental, and that is healthcare decisions. So let me share the screen here. Share sound. Okay. And sit back and relax and watch the video.
Zach's sister Emily helps him make decisions about healthcare. Let's see how he shares his supported decision-making agreement with his primary doctor.
Yeah, it's very hard to distance. It's really hard to stand, but my sister can help. A few things that don't know what I'm talking about, but yeah, I just make me feel better. I felt really happy she can help me with my own decision.
Yeah, and I help you explain things to the doctor too. Like sometimes the doctor doesn't understand what you're saying, and I can help the doctor know what you're talking about too.
Yeah.
Welcome.
Welcome. I have an agreement for you when you look at.
Okay. Exactly what is this?
Emily, can you help me out here?
Yeah, I can help you. This is to allow me to help Jack make decisions about his healthcare.
Have you been tired or have you been jittery?
Emily, what is jubilee?
Jittery means like if you feel like kind of antsy and shaky and a little bit hyper.
Have you been that way?
No.
Okay.
I've been that way.
I've been helping Jack his whole life with all sorts of decisions. I'm 10 years older than he is, and so since he was born, I've been helping to be an advocate for him and to help him decide what the best choice would be for his life. Really have to make sure that you aren't doing what you think the best choice for what you think the best choice is for the person that you're supporting. You really need to know and talk to them about what they want and what choice they want to make, and support that even if it's not the choice that you would make personally. Jack does not like to wake up early. He likes to wake up afternoon on most days, and a lot of times I think it would be better for him to wake up a little earlier and have a morning and get things done. But in his life, that is not an enjoyable experience. So I have to help him plan things for the afternoon or evening so that he can have the mornings the way he likes and enjoy his life the way he wants to. And then he can still do the things, but at a later time.
I'll ask your friend, maybe you ask your brother, your other sisters too.
Yeah, it's important to ask someone who knows you, so that they know how to explain what you're saying or what relates to you, and how best to explain things, and who knows your life, and so who can help you make the best decision for yourself.
Yeah, I just like somebody to help them. When people want to help someone, people ask your father or your sisters, maybe your friends, maybe your best friend, and have somebody you want. It's very good to ask.
It's important that people who have a hard time making decisions have somebody who can help them and who can explain things and who can help them make good decisions.
Okay, sorry about the dead air there, but that encapsulates supported decision-making in action. And something that Jack said that was so key there was it's important to ask. And that's what when we create a community that's an inclusive community for individuals with disabilities and everyone else, the ability to know when and how to ask for help, and to not feel like asking for help is something that you should not do, to feel empowered to ask for help. And there's a great advocate who's been to Nevada, who's maybe on a handful of occasions talking about this concept. Her name is Janice Fielka. She's the mother of one of my best friends, Micah Fielka Feldman. She talks about the idea of inclusion as being a dance, and that when we engage in asking for help and finding structures for assistance, it's it's like finding the rhythm when you're dancing. That it's a delicate dance, but it's an important dance. And we dance with each one of us in the community a little bit differently to get that support as we move forward. So let's jump back into the slides right now and go through some particular specific items related to supported decision-making agreements that are helpful in thinking about supported decision-making. So supported decision-making, as I said before, is the least restrictive manner of decision-making. That means that the arrangement when thinking about decision-making should start with supported decision-making. And then other more restrictive options can be pursued. There's a new part of the guardianship law in Nevada as of October of last year that says lesser restrictive alternatives must be reviewed and investigated before you can petition for guardianship. That means that with supported decision-making, we also have a law that identifies you should start with supported decision-making. Guardianship, other more restrictive options should come second, third, or fourth. And this, for each individual, should be where we start when we think about decision-making for an adult with a disability. Guardianship should be the last resort. What is the difference between supported decision-making and guardianship? This could be a whole presentation in and of itself. I'm going to go through three distinctly important differences. One is, under guardianship, a district court determines that an individual lacks capacity and appoints someone else to make decisions. Under guardianship, an individual loses fundamental rights. In some circumstances, an individual loses more rights than somebody convicted of a felony who is not incarcerated. Second difference, supported decision-making agreement allows an individual to select who they would like to assist in their lives in making decisions. Guardianship is appointed by the court, and the person who would like to be the guardian petitions. Third, guardianship requires court involvement. Full stop. Supported decision-making does not involve the court. Those are the key differences. We could go on and on about other differences in more detail, but the takeaway from today's presentation is based on those fundamental principles there related to those differences.
Alex, if I might ask a quick question
Yes.
On this topic, I think a little confusion in the community is, guardianship has to be filed, right? There's a place that it lives.
Yes.
Supported decision making, is there a need to file somewhere? And okay, if you could explain that, that would probably clear some things up.
Absolutely, yes. And I think I do get to that in a second, but ultimately, a supported decision-making agreement is not, so guardianship is filed in a court of law. Supported decision-making exists separate from that court, and there's no place in which this needs to be supplied to any court or oversight agency. Now, I encourage folks to provide supported, if you've got a supported decision-making agreement, to give it to your service provider or to supply it to your doctor. But there's no requirement that this be filed in any particular place. There's also something called the Nevada lockbox, where you can put your estate planning documents, wills, powers of attorney. You can put a supported decision-making agreement there, but it's not required. And this is a great question, Maria, because there's no requirement that a supported decision-making agreement be filed anywhere under any law.
So if I can give a personal example, because we have a supported decision-making agreement with our daughter, we had her give it to her doctor. And now for the past few years, he will only sit and talk to her until she says, asks us a question or asks us to help her. So it has given him the ability to recognize that she wants to make her own decisions. Otherwise, a lot of times providers of any kind talk to the parent until the parent asks, their young adult a question. So it changed the viewpoint of the provider to our
That is
daughter.
Great story. And it shows that there's often gradual understanding as a person's philosophy changes in thinking about these types of structures. It's a
Yes,
great story,
yes.
Maria. Something
So-
else too that's key with that, with the change in how a person reacts, is a lot of times the supported decision making is the starting point, but it becomes just natural. So there's no longer, you don't need to every time go up, I've got this right here. That structure of inclusion then becomes standard for those interactions.
Yes, yes. Now, Jen asks, will you go into how you decide whether to use guardianship or supported decision making?
Yes, I
Okay.
will. I'll be sure to emphasize again the idea that guardianship is the last resort. So you start with supported decision-making agreement, you start with lesser restrictive alternatives. But there's a fundamental piece that I'll get to in a second that we have to consider. And this is the biggest challenge in supported decision-making agreements, because there are circumstances where guardianship may remain necessary. So that's a great question.
Okay. And Eileen just says, what's the difference between the person and a patient advocate? So Eileen, are you asking the individual themselves with the disability? What's the difference between them and a patient advocate? You can unmute yourself. She said this agreement.
Right. There is a patient advocate is different than a supporter in a supported decision-making agreement, because of the fact that the supported decision-making agreement is defined under Nevada law. A patient advocate through a structure in a hospital is something beneficial and could be an important component in somebody's healthcare. However, that is different than a supporter in a supported decision-making agreement, unless if the person with the disability chooses the patient advocate to be their supporter. It does not, however, mean a person cannot have a supporter and a patient advocate at the same time.
Okay, so they're different.
Yes, they're different, and they can work hand in hand, though, as well. But great question. Have not had that question asked before.
Okay, thank you.
Yeah. All right, so let's now move on to if a person with a disability already has a guardianship or has a power of attorney. So if a guardianship already exists, you can do one of two things with supported decision making. You can, one, start to apply the principles of supported decision making to test out and work with the person to try to see if a supported decision making agreement might be meaningful. Because supported decision making agreements are from 2019, a lot of guardianships exist before then, so it may not have even been part of the process. However, a person cannot enter into a supported decision making agreement prior to the termination of a guardianship, because when a person has a guardianship, they are found to be incapacitated. Now, you can use the supported decision making agreement as a demonstration of a reason for termination as a lesser restrictive alternative. A person under a guardianship can petition to terminate, or with the guardian can stipulate to terminate the guardianship in place of a lesser restrictive alternative. However, in those circumstances, you will need to demonstrate to the judge by clear and convincing evidence that the person has regained capacity with support from supported decision making, and you will need a physician certificate to identify that the person has regained capacity. That's why once a guardianship is obtained, it is very difficult to look at lesser restrictive alternatives, which is why it is the last resort. If a person has a power of attorney can be used in tandem with a supported decision-making agreement. A power of attorney is a similar type agreement where a person identifies an agent to assist with their decisions, either related to healthcare or finances, and a supported decision-making agreement can work as one additional tool to a power of attorney. How is a supportive decision-making agreement different from a durable power of attorney? Well, the difference is that a durable power of attorney will continue to exist. The key term is durable if a person loses capacity. So if you have a durable power of attorney, then if the individual, say, is in a coma and can no longer make decisions, that durable power of attorney will continue and allow the agent to assist in making decisions. However, a supported decision-making agreement, if something like that were to happen, would not continue because the individual would not be in a position to make decisions. Also, a durable power of attorney. There are a few flavors to the powers of attorney under Nevada law. And since 2015, thanks to a couple of really strong advocates, including Mary Bryant, there was a change in what is available to individuals with disabilities. And there is a durable power of attorney for healthcare decisions for individuals with disabilities that is tailored to allow individuals with intellectual disabilities to have a power of attorney, and that power of attorney is written in plain language that is understandable by more individuals and individuals with disabilities. Okay, if you have a healthcare power of attorney for a person with intellectual developmental disability, should I have a supported decision-making agreement? I strongly suggest yes, because what that does is it creates yet another structure for assistance in supporting an individual with disabilities to retain their decision-making. What's also important is a healthcare power of attorney does not cover so many different topics that a supported decision-making agreement can. Remember, a supported decision-making agreement can assist a person in making decisions in every aspect of their lives. Healthcare, finances, where they live, who they interact with, dating, travel, employment. Healthcare powers of attorney often is more restricted in that regard, but the two work hand in hand. And in both of these types of tools for decision making, the person retains their rights. And like we said before, the idea behind supported decision making is about the structure of retaining rights for persons with disabilities. Both of these are not the most restrictive decision-making tools and allow a person to continue with their rights. So a few features under NRS 162C that I wanted to identify. This is in law. The first is that, as we said before, that a person with a disability is the best person to make choices about their lives. Nothing about us without us. Also, Nevada's supported decision-making law is important because it affirms that needing assistance in aspects of daily living should not be a barrier to continuing the recognition of a person with a disability being the ultimate decision maker in one's life. So it breaks down those barriers and somewhat of an accommodation for an individual to retain their rights and to be their decision maker. Also, the key feature in the law about where a person fits is the decision maker is at the center of the supported decision-making agreement, and that the supporter importantly has legal standing to assist the principal. Like Maria talked about, that supported decision-making agreement goes to the doctor. She has legal standing to support if her loved one is interested in having support and has this agreement. She has legal standing so that a doctor can't say, well, this is a person over 18. We can't talk to you. Well, no, if the principal wants someone to be engaged, this is the way to do it. As a matter of fact, the law also has some limits to the actions of supporters. So supporters cannot, under law, exert undue influence. The supporters cannot make those decisions on behalf of a person. The supporter cannot obtain information without the person's consent, unless the agreement identifies that there is a consent component or another document that allows for these rights to be transferred. A supporter cannot use the information for purposes other than helping the person make decisions. So it has to be about what the principal wants. The supporter has to act with care, competence, and diligence. And the supporter naturally has to keep information privileged. unless if the principal says, hey, there's a compelling reason why that needs to be shared. Okay, this goes to the fundamental question that was asked about guardianship versus supported decision-making agreement and how one can think about the two. The most important part about a supported decision-making agreement is that the person must enter into an agreement. That entry must be voluntary and without coercion. So if a person cannot voluntarily enter into the agreement or do so without coercion, then a supported decision-making agreement is not a tool that is best for that individual. Now, it might take some time. I've worked with the family developing a supported decision-making agreement that took months because of the fact that the person had a significant disability, a severe disability that limited and made communication a little bit more complicated. But by using accommodations and modifications, that person was able to enter into the agreement and create a structure for them to be involved in the decision-making in their own lives. So that's the fundamental piece. If a person cannot understand the agreement, so if a person is in a coma and is unable to communicate their desires, then that person would not be able to enter into the agreement. However, like I said, aside from those extreme circumstances, there are ways in which at least there can be an attempt to pursue whether or not this agreement is possible. Importantly, the person with a disability must understand the nature and effect of the agreement. So with that comes discussion, collaboration, and the person with the disability identifying their needs. Those are the key pieces to that question asked about what is necessary when thinking about these discussions. That is key. However, it is not merely just a cursory review of, okay, well, they can't really understand this, so let's go with guardianship. It's worth working with the materials. It's worth applying the concepts in the IEP, looking at the accommodations, modifications, and supports in the transition portion of the IEP and everywhere else to see if there might be a dialogue and an iterative process that allows an individual, even with a significant disability, to understand this agreement. Because the agreement is fundamentally basic. And I'm going to go through those specific requirements of what is needed in an agreement under law. One is the person with a disability must be called the principal. The agreement must, 1, be in writing, 2, be dated, 3, designate one or more supporters, 4, list the types of decisions the supporter is authorized to assist with. Also, list the types of decisions the supporters are not allowed to help with, if there are any. Sixth, be signed by the principal and all supporters in the presence of 2 adult witnesses. A supporter cannot be a witness. And 7, remember, supported decision-making agreements do not require a notary and do not allow for the process of a notary to execute the agreement. You only need 2 adult witnesses to sign. There's no structure under Nevada law for a supported decision-making agreement to be notarized. And that is helpful because what it does is it does not require families to have to go through that additional process to get those types of additional requirements. The principal and supporter need to communicate the agreement's existence to service providers and can give a copy to service providers. I strongly encourage that, as Maria identified. Also, the supported decision-making agreement's existence cannot be used as a reason for pursuing guardianship. So if a person says, hey, I need a little additional support here, you can't then use that as a petition, as an exhibit in the petition for guardianship. But in short, the supported decision-making agreement identifies the people and tools that will support the person in making their decisions. Those are the requirements under law. And we will supply the ins and outs of this in the resources accompanying this presentation. So you don't need to commit it to memory. And I always have my cheat sheet with me to make sure I get everything down. Additionally, it is an ongoing process. It's going to be 7 years old in July. Supported decision making in Nevada is still a learned skill. It is something that can be changed to update areas of supported decision making, areas of need for the principal. And if there is no longer need in certain areas, it can be changed too. You just have to go through that same process to make the adjustment, have it signed again, and have two witnesses there for the signing of the new agreement. Like I said, it can be terminated verbally or in writing, and a new agreement can replace that agreement. Supporters often are changed because a person's life changes. It's important to note too that there can be more than one supporter. You can identify one or identify 10 supporters. You can have the variation of how those individuals support, and there can be successive alternative supporters. So if somebody is going to step in upon the removal of another, say, unfortunately, if there's a death of a supporter or incapacitation of a supporter, you can have somebody else designated as a supporter and how they will support as they move forward. There are a whole other set of lesser restrictive alternatives to guardianship that we've talked briefly about that I kind of wanted to go through here. These are all materials that can help an individual in making decisions, including release of information, a person-centered planning agreement with your regional center, a case manager, a representative payee through Social Security. That allows for an individual to assist with finances, power of attorney for healthcare, power of attorney for non-healthcare matters. And there's two distinct types of power of attorneys. One is durability. That means it remains when a person has capacity, and if a person were to lose capacity, say go into a coma, the POA continues. Springing is a power of attorney that exists only when somebody has a life-altering event, like going into that coma. It would spring into existence at that time. There are limited and special guardianships that are also available if there are certain areas of need related to a particular area where a person is unable to make decisions. That, of course, would require a petition be filed in court by the person pursuing guardianship. And then, of course, full guardianship. People often say permanent guardianship. There's no such thing as permanent guardianship because guardianship would ultimately terminate upon the death of an individual or the guardian, and plenary or full guardianship is the term that we use. Some tools in supported decision-making that support an individual include plain language, giving information by visual or hearing methods, extra time to discuss, role-playing activities, bringing a supporter to meetings to take notes. There's a multitude, and in the materials that we will supply, there will be more investigation in what might be available. Again, remember natural supports, which may already have a structure for supporting the individual with a disability in your families. Does the agreement need to be registered with the state? No, it does not need to be registered anywhere, as we discussed earlier. I want to talk briefly for the next couple of minutes about a success story. A gentleman named Connor Fogel. A little bit about Connor. He had gone to Marvin Piccolo School up in Reno. After high school, a guardianship petition was filed and his parents became guardians. They were not told of alternatives to guardianship, and this was prior to supported decision making. By the way, if a guardianship occurs, then the person, the protected person, the person with the guardian, is appointed an attorney by the court to represent the individual in that guardianship proceeding. Through that attorney, Connor learned that a guardianship interferes with fundamental rights, including the right to marry. Now, there are protected persons Bill of Rights that has existed also under statute, but in certain circumstances, those rights are limited because of the guardianship. So Connor went on a quest at the start of the supported decision-making law to terminate his guardianship, and since then has had a supported decision-making agreement. He now has many professional successes, including all of his rights. And this is a great quote from Connor. I like how I can do things on my own without a guardian. I could do stuff on my own now, and I can get married and no one asks if I have a guardian. It's great. Nothing about us without us, as I talked about before. Where can you learn more? I don't know. Is Catherine on the line, Maria?
I still don't see her.
Okay, so I'll go through this briefly. There is a website specifically about supported decision making in Nevada, the Nevada Center for Excellence in Disabilities and the Governor's Council on Developmental Disabilities. Is fundamental in the development of this website. Everything that we've talked about today and more is there. You've got tools, you've got resources, life stories, success stories, the videos that we saw today, and so many more, including a great frequently asked questions section. In addition, there's a national resource for supported decision making, supporteddecisionmaking.org, that goes through each state in case you want to look at potentially moving and leaving Nevada. I hope you don't. Nevada's the best state in the nation, but also looking at what is happening in other states. And when you go to that website, you'll see Nevada has one of the best laws for supported decision making. The American Civil Liberties Union also has a clearinghouse of information available on supported decision making, which reinforces the idea that supported decision making is about constitutional rights. And of course, the Governor's Council, Nevada Department of Health and Human Services, and the Center for Excellence in Disabilities all have resources related to supported decision making. So thank you for joining us today. I imagine there may be a couple of questions that I can entertain before we conclude today's session. Maria, do we have any questions on the list?
Yes, thank you. So does it need to be the same two witnesses that modify the supported decision-making agreement?
No, great question. And it doesn't modify the supported decision-making agreement. This might sound like a technicality, but what will happen is if there is a change needed, is the old agreement will be terminated. You can take the template from the old agreement, add what you need to add, and then a new agreement will be created on that day. The supported decision-making agreement has to be dated. So the new agreement will have a new date and will be a completely new structure for decision-making, even though it might just be a small change. And I have done that in my practice on occasion and have run into no problems. Of course, if you have questions and want to do that, please reach out to my office.
Great. Do you have more information about the Nevada lockbox?
Yes, the Nevada lockbox is available. You can submit through, I think it's the Health and Human Services website, and that lockbox will make your estate planning materials, including a power of attorney or supported decision-making agreement, available to state providers and available to others. So decision-making documents are available to those who will require, well, maybe not require, will benefit from those materials. So this is something that's often used for seniors, especially when it includes wills and so forth.
Great, thank you. And then Kamala is really well versed in this. So she recommends when traveling, she takes her supported decision-making agreement and her POAs or has a digital copy on her phone to be just in case.
Yeah, I would thank you so much for sharing that. I would encourage everybody to do that. And if you've got letters of guardianship, if there is a guardianship, take that with you. I think that is, if you're going to remember one thing from this presentation that wasn't in the slides, that's the thing to remember. Great job, Kamala.
Thank you. Thank you. Eileen asks any other docs that we should carry medical information when we're traveling. Any ideas?
Yes, powers of attorney, supported decision-making agreement, anything that identifies representative payee is key. And personal identification is always helpful too.
Does appointing a power of attorney require court?
Great question. No, a power of attorney agreement does not require any involvement from the court, nor does it restrict or remove any fundamental constitutional rights. A power of attorney either requires the agreement to be executed in front of two witnesses who are not involved in the agreement and not that are separate and independent witnesses, or a power of attorney can be executed with a notary.
And Kamala's recommending, always having likes and dislikes of the individual on hand, and you creating a private YouTube video with any information that might be necessary.
Great. I had not thought of that, but I will adopt that and I recommend it. I love the recommendation.
And Kamala also says Great Basin Credit Union will notarize POAs for free if you are a member.
Yes. And many of the banks do provide notary services for free. I know some places, some libraries that are hubs for community work have a notary. So the Humboldt, I often execute documents at the Humboldt Library. As a matter of fact, there's a gentleman there who's a notary. The library said, hey, they want a notary on hand, and guess what? He's free of charge. Also, if something comes up and you need our services, our office does have notary services as well. In Vegas, I would call the library too. They might be able to do it as well. You can also contact me at my office and I can provide resources or referrals or even maybe do something here at our office if you need.
That's great. Thank you. I'll be sending out a follow-up email with a supported decision-making agreement, healthcare power of attorney, financial power of attorney. So all of these things will come your way, as well as anything that Alex is going to send my way. So everything that Sky gave us as well, all those links will be connected in a follow-up email. Does anybody have any further questions for Alex before we move about our day? I don't think so. Alex, thank you so much for taking your time to come today on a Saturday. Everybody for joining us. Eileen says very high quality presentation. Thank you, Alex.
Thank you so much, Maria and Marcia and everybody here today. I usually like to conclude my legal information presentations with this fact. Knowledge is power and knowledge is justice. So you've got power and you've got justice and you can move forward to make it happen. So thank you so much for listening today, and do not hesitate to reach out if you have any questions.
Thank you. Thank you so much. Have a great day. Thank you, everybody. We have a survey. So if everybody would just it's literally like 90 seconds. It's going to help us to know how to, serve you all best. There's a QR code there to the survey. It would be super helpful if you all would fill this out for us.